Hi everyone. Firstly, I would like to uh, introduce you to my group members who are Nabin, Sobit, Farooq, and Suraksha, and myself, Subikia. So we have decided to do part A, option 1, which is the So Burgers, and part B, option 2, which is the Joytronics Private Limited. So I'll be starting with the introduction. Business and corporate law deal with the rules and regulations needed for doing business legally. Two situations or problems in two parts will be solved accordingly to the business and corporate laws. The first part will be based on contract law, and the second part is all about the corporate law. Now I'll be talking about part A, option 1. Uh, Contract law is that kind of law where there is an agreement between two or more parties and may have a matter of consideration for the transaction. So the issues here faced by So Burgers are: is So on the legal side to cancel the competition? Is So legally bound for meeting the demand made by Brett and Mikey? Whether both Brett and Mikey will be able to get the demanded car by suing. So the rules for the contract. There is a rule of an implied contract of contract law. An implied contract is that matter when a party has announced a consideration in exchange for some acts, but other parties have not given consent but are encouraged to do the acts by the announcer. In this particular case, the announcer will be bound to provide consideration to those people who have completed the specific acts. Therefore, there is a breach of contract and remedy. Now, I would like to call upon my friend Sobit to continue with the presentation. Thank you.
Hi, my name is Suvit Lama, and I'm going to continue with the analysis of the issue that was presented by Suvigya. So, while doing the analysis, it was found that the first winner of the car, that is Michael Mikey, was very keen and interested in winning the lottery. So, as soon as he heard about the offer, what he did was he purchased 50 hamburgers, and out of 50 tickets, he was lucky enough to have one golden ticket. And it was also found that he was hospitalized for overeating all those hamburgers. And so to claim his car, he went to the head office of the restaurant. So he deserves some compensations or remedy for his loss and damage. So similarly, the second winner was Braid. So while analyzing the bread, it was found that instead of purchasing any of the hamburgers, he collected all those tickets, that is 100 tickets from the rubbish bins, and he was also lucky enough to have two golden tickets from the 100 tickets. So he also went to the head office to claim his car. And as we can see that uh, he does not deserve the car or any of the compensations. So what we can conclude is that by the law and order, it's Michael Mikey who legally deserves the compensations for his loss and damage, as compared to the Brit, who by law is considered as fraud. And so at last, the SOO Burger Company, what they should do is that they should gather all the relevant and sufficient information about the potential winner of the car. And that's obviously is Michael Mikey, as rather than Brit. Um, so with this, I would like to hand over this video to Surekha to continue the rest of the presentation. Thank you.
Thank you, Sobit Lama. This is Ms. Suraksha Wagle. As I am talking about part B, option 2, there are two options, and we have chosen second option, which is about Joy Tonic Private Limited. As Joy Tonic, talking about Joy Tonic, there are three shareholders, and they are operating in retail store in Sydney, and the main branch is in Sydney CBD, where there were not any other companies. And there are many issues, which is divided into two sections, and there are three issues in one section. And one of the issue is what is the legal position of Mercedes about breaches of her general law or statutory duty of care and diligence as a director. And second issue is, was Mercedes' decision to agree to the purchase of the new premises protected by Section 182 of the Corporation Act 2001. And the third issue is Mercedes liable for breaching 580 of the Corporation Act 2001, becomes insolvent? And there is only one issue in part B. What are the possible liabilities of Grox breaches of the duty of care for insolvent trading if Joytronics becomes insolvent? And my next topic is rule. According to general law or statutory duty of care and diligence, a director have to exercise care and diligence when they play his or her role. And second rule is Corporate Act 2001, Section 180, which includes business judgment rule, which indicates that a director of corporation makes a business judgment to make the judgment in good faith and faith, not for his or her interest, rather for the interest of the business corporations. And next rule is 588G of Corporate Law 2001, that tells about the director's duty to prevent insolvent trading. And the last rule is civil and criminal penalties. Now I would like to hand over to my friend Said Farooq, who will continue with the presentation. Thank you.
Thank you, Suraksha. As my friend Suraksha mentioned about the issues and rules part, I'll be continuing with the analysis part. Myself, Syed Farooq Ahmad Sabri. Mercedes is a non-executive director who is not actively involved in the operation. He just delivers capital, takes part in the meeting, takes profit, and bears liability. And there is an issue to provide advice on. That is to identify what is Mercedes' legal position about breaches of general law or statutory duty of care and diligence. Mercedes needed to look after any good place for business transfer. She breached the general law or statutory duty of care and diligence. According to section 180 of 2 is all about business judgment rule, which indicates that a director will do business judgment in good faith for the interest of well-being of business rather for personal interest. Mercedes may not be sure about the decision. She thought that Felix is directly connected with the business operation, so he will understand more than me. Therefore, Felix told her the place is good and will not exist if they do not finalize the decision to purchase that very quickly. Now, according to section 588G of Corporate Law 2001, a company becomes insolvent by incurring debts, or there may have a reasonable ground for suspecting a company to be insolvent. Joytronics first head store was in Sydney CBD, and the company was not performing well. Although Mercedes did not know the situation of Parameta for the business like Joytronics, she gave her consent just by getting a positive review from Felix. Whatever the case, as Mercedes has given her consent, she will be liable if the business becomes insolvent. Now my friend Mr. Nabeen will continue the rest of the part. Thank you so much.
Thank you, Syed Farooq, and it's me Nabeen Bhandari, and I am just talking about the analysis B. Since my friend is talking about the analysis A, I am going to talk about the analysis B and the conclusion of our presentation. So in analysis B, we talk about the Greg, which is one of the 3 directors of Joytronics, and he has dropped out of school in very early in his childhood. That's why he know a little bit lower than other directors. He also took consent on purchasing Parameta land for the company. As he also gave the consent, he had to face different types of criminal and civil penalties. Therefore, he will be personally liable of compensate for the losses. The civil penalties for the director are substantial fines for them, disqualification from the managing of a company, and paying compensation of the company equal to the losses suffered by the creditors. If the insolvent trading is dishonest, criminal penalties will be brought. So next, so I am just talking about the conclusion of that situation. In the conclusion is that it concluded that legal position is that Mercedes breached the general law of the care and diligence. The decision made by the Mercedes according to the corporate law section 182 will be protected. Mercedes and Greg will be for breaching and 588G and the duty of care. So, and I'm next I'm talking about the conclusion of whole my presentation. So every problematic business situation may be solved by the business professional by following a method like IRAC, or IRAC is used to show the legal issue in case of situation given in the question paper. In the first part, a situation related to the SO burger has been solved through the following the IRAC method, and in the second part, the situation has been described related to the joy training and the branch transfer. In the both cases, firstly, the issue related to the case have been described. Secondly, related law has been shown. Thirdly, an analysis has been carried on to find out the solution of the raises issue, and finally a conclusion has been drawn. And this is our conclusion of whole presentation and our assignment, and this is our research and analysis. Hope you like it. Thank you.